Today, we will discuss successor liability risks in the mergers and acquisitions context. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees and a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Successor liability in asset transactions remains one of the most misunderstood aspects of mergers and acquisitions. Buyers often assume that an asset purchase arrangement clearly and finally eliminates historical liabilities of the seller, but this belief is at best incomplete and potentially dangerous. Courts and regulators alike may impose obligations on the buyer through doctrines such as de facto merger, mere continuation, express or implied assumption of liabilities, and fraudulent transfer and conveyance statutes. Industry-specific laws on taxes, environmental matters, employment and labor disputes, and product liability can attach responsibility to the buyer despite precise contractual disclaimers to the contrary. As a result, asset deals may shift the shape of risk but rarely eliminate it altogether. The determination as to whether successor liability attaches or should attach is highly fact dependent, varying across jurisdictions and industry verticals. Seemingly small operational decisions, such as retaining employees, using the same branding, or maintaining the same customer and vendor relationships, can provide plaintiffs or agencies with evidence of continuity. Mitigation is therefore a multidisciplinary process that requires ongoing coordination across law, accounting, tax, human resources, and operations. Effective mitigation begins long before the asset purchase agreement is drafted and executed. Buyers must build a risk map that identifies possible successor liabilities, evaluates them by likelihood and magnitude, and establishes diligence procedures for each. Standard financial statements and seller questionnaires are simply insufficient. Buyers must engage in granular reviews, including detailed reconciliation of tax filings, verification of payroll deposits, environmental site assessments, sampling of timekeeping and wage compliance records, review of product complaints and warranty reserves, and even reconciliation of sales tax obligations across jurisdictions. In higher risk categories, regulators should be engaged early and often to determine if clearance certificates or voluntary disclosure regimes are applicable. Comprehensive mapping of risks at the outset avoids last-minute revelations that could derail the deal. Structuring the deal to avoid findings of de facto merger or mere continuation requires conscious deviation from the seller's footprint. What do I mean by that? Buyers should avoid unnecessary continuity in branding, governance, capitalization, and contract structures unless deemed absolutely necessary. Paying consideration in cash rather than equity, changing names and marks, reconfiguring facilities, and entering into new relationships and new contracts rather than assuming existing ones can all counter arguments of continuity. Where business exigencies require retaining staff, maintaining brand presence, or preserving customer and vendor relationships, these should be documented with independent business justifications and offset by other structural changes that clearly demonstrate independence. Counsel should prepare a jurisdiction-specific checklist of factors courts consider and ensure that the deal team implements appropriate safeguards. The asset purchase agreement itself is the central risk allocation lever. It must clearly delineate which liabilities are assumed and which will remain with the seller, avoiding vague phrases that invite judicial expansion and reinterpretation. Representations and warranties must be highly tailored, covering tax compliance, payroll remittances, wage and hour compliance, environmental issues, product safety, and pending or threatened litigation. Survival periods, baskets, and caps should be calibrated to the risk profile identified in diligence. The buyer must retain leverage through escrow rights, indemnity access, cooperation covenants, and record retention provisions. Generic representations and vague indemnities are inadequate because they may be subject to survival limits, financial caps, or collectability risks. Escrows and holdbacks funded at closing provide tangible security that indemnities alone cannot. Tax liabilities are particularly resilient to contractual disclaimers. Many states impose successor tax liability notwithstanding asset deal structures, especially with respect to trust fund taxes such as sales tax and employee withholdings. Buyers therefore should pursue tax clearances wherever available, reconcile returns with ledgers, and confirm that all registration accounts are active. Payroll, trust fund, and sales tax exposures require heightened attention because they create, in many cases, personal liability for responsible persons and often cannot be discharged by indemnity. Escrows conditioned on clearance certificates or the expiration of assessment periods provide protection against these persistent risks. Employment liabilities also follow continuity doctrines, particularly with wage and hour statutes. Buyers must review timekeeping, overtime practices, classification of workers, and any prior regulatory investigations and the results thereof. Benefit plans require diligence on ERISA compliance, Form 5500 filings, COBRA, and potential withdrawal liability from multi-employer pensions. Where employees must be rehired, compliance with federal and state WARN statutes is essential. Environmental obligations can attach regardless of contractual allocation. A Phase 1 environmental assessment is the baseline. If red flags arise, buyers should commission Phase 2 testing, consider insurance, or exclude contaminated parcels from the deal. Product liability exposure is equally resilient, with some states imposing product line successor liability where a buyer continues to manufacture or support the same goods. Therefore, buyers must evaluate product complaint histories, recalls, design changes, and warranty practices, and may need tail insurance or rebranding strategies to minimize exposure. Fraudulent transfer law poses a separate risk where sellers are insolvent or will soon become insolvent or receive less than reasonably equivalent value. Buyers must ensure purchase prices are supported by defensible valuations, obtain solvency certificates, and avoid insider or rushed transactions. Proper notice to creditors and strict adherence to statutory processes can further safeguard deals from fraudulent transfer or fraudulent conveyance challenges. Contract assignment rules can also create unintended and unanticipated liabilities. Many contracts contain strict anti-assignment clauses, and informal continuation of seller contracts without obtaining appropriate consent can be construed as assumption of obligations. Buyers should prepare a contract matrix, seek consents or novations as appropriate, and establish new agreements where possible. Insurance contracts often cannot be assigned, requiring new policies or tail coverage. Representation and warranty insurance can supplement escrows, but is limited by exclusions for known risks, taxes, and wage and hour violations. Tail coverage for directors and officers, cyber, environmental, or product liability insurance should be secured to protect against these legacy claims. In distressed or bankruptcy sales, Section 363 processes provide enhanced but not absolute protections. Environmental, pension, and ongoing statutory obligations may still attach. Buyers should negotiate sale orders with precise liability carve-outs and provide comprehensive notice to potential claimants. Distressed acquisitions increase risks of fraudulent transfer challenges and require deeper diligence and stronger escrows. Integration planning after closing must continue to reflect the overall legal strategy. This means that branding, communications, HR policies, accounting systems, and supplier relationships should demonstrate independence. Business as usual messaging can undo careful structuring by bolstering successor claims. Buyers should contemporaneously document operational challenges to provide evidence against findings of continuity if challenged in subsequent litigation. Creditors should be notified of the transaction even where statutes do not strictly require it. A defined claims intake and response protocol should be established to prevent small trailing obligations from snowballing. Buyers must anticipate and plan for warranty claims, tax notices, and service of process, and allocate responsibility for triage and insurance tender. Common misconceptions that increase exposure needlessly include the false belief that asset deals automatically eliminate all liabilities, that indemnities guarantee recovery and collectibility, or that the absence of known claims equals the absence of risk. That is not the case. In reality, many liabilities arise during audits or investigations years later, and indemnities are often limited by collectibility and contractual terms. A practical checklist for mitigating successor liability involves diligence, structuring, contractual protections, and integration planning. Before signing, buyers should conduct targeted diligence, identify contracts requiring consent, and align structural and operational decisions to minimize continuity risks. At execution and closing, precise assumption schedules, tailored warranties, escrows, and indemnity provisions must be finalized. Post-closing, integration plans should emphasize operational independence and maintain active claims management protocols. Periodic reassessment at 30, 90, and 180 days post-closing is critical to adjust reserves and policies as risks materialize. The complexity of successor liability requires integrated legal and accounting expertise. Attorneys anticipate jurisdictional pitfalls, draft enforceable agreements, and guide competent structuring, while CPAs can reconcile findings, analyze exposures, and quantify risks. Self-navigation of these treacherous waters often results in unanticipated and totally avoidable liability when regulators or plaintiffs surface post-closing. Buyers therefore should balance risk mitigation with their ethical obligations, ensuring that structuring strategies respect creditor rights and statutory requirements. Attempts to evade obligations through bad faith structuring invite severe penalties and reputational harm. Ultimately, disciplined diligence, precise structuring, contractual safeguards, and post-closing integration aligned with competent legal strategy allow buyers to unlock deal value while responsibly mitigating successor liability risks. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.